Hello, my name is Tig Wilson, Senior Associate and Certified Financial Planner for Pearson Hardman LLP, here to deliver our video estate plan for clients Nicholas and Katie Madison. Let's get started. After reviewing all the important documents, we have come up with 5 key areas of concern for the Madison's estate plan. Now, the first and the primary issue that we've identified is Mrs. Madison's current lack of a will. This opens up the family to what's called state intestacy law. What are state intestacy laws and why don't we like them? To put it briefly, state intestacy laws are going to be those laws which the state defaults to in the event of somebody's passing. Now, don't get me wrong, state intestacy laws absolutely have their place. However, that's going to be mostly for more basic and less nuanced estates. The more complicated we get, the more we want to be avoiding state intestacy laws wherever we can. Now, a large part of creating a will and estate planning in general is going to be creating estate goals. This involves answering questions such as who needs to inherit, what are they going to be inheriting, and what contingent plans do we need to make if something were to go awry. These are questions that Katie specifically is going to need to answer, as she doesn't have a will and they can be addressed therein. That's not to say that Nicholas shouldn't be a part of this process. We highly encourage that both spouses align their goals and values as much as possible to make sure that there's no contradicting information. To that end, Nicholas himself may need to revise his own will. The second problem we've identified are trusts. Trusts are a powerful vehicle for transferring assets within a family and are currently being underutilized by the Madisons. Trusts are made up of 3 distinct parties. First off is going to be your grantor. This is going to be the individual who actually creates and funds the trust, in this case, the Madisons. The next party is going to be the beneficiary or beneficiaries. These are going to be the people who actually derive a benefit from the trust, however the trust is made out. And third is going to be the trustee. This is going to be the individual who follows the trust to the letter and actually manages the trust assets. You cannot have a trust without all 3. Why do we care about trusts for the Madisons? One of the big reasons is going to be their unique family dynamic. Nicholas has 2 children from a previous marriage, while he and Katie both have 2 children of this marriage. This means that should Nicholas pass first, Katie's inheritance may not automatically go to the 2 surviving children from Nicholas's previous marriage. We don't want to see that happen. We want to build a vehicle which can protect inheritance for all 4 children. That is what makes a trust so valuable. The type of trust we recommend for the Madisons is going to be a revocable one. Revocable for trusts simply means editable. This is great for the Madisons because it means that they can add new people to the trust should they have other children or other family or friends they wish to add later. The third key issue we want to address is one of guardianship. Guardianship is always a great concern to us whenever we see minor children as part of an estate. We want to make sure they're protected, and the first step in that is guardianship. A guardian is an individual selected by the court to look after a child's interests as far as health and welfare after their parents have passed. Now, a court does not have to agree with a parent's choice of guardian. However, outlining one in a will does highly impact the court's choice. That's why we want the Madisons to come up with an individual to become the child's guardian. Anybody chosen for guardianship should be a mature individual, capable of taking care of the children in a loving and caring way. This means they should be on good terms with the children already, know the family very well, and have a good track record with other children. Now, the guardian of the trust need not necessarily be the most financially savvy. The trustee of the trust is going to be the one actually looking after the money for the children. Instead, the guardian should be on good terms with the trustee to avoid friction between the 2. Alternatively, and if applicable, both the guardian and the trustee can be the same individual. Either way, a lot of thought should be put into choosing both trustees and guardians to make sure that the right person is chosen for the right job. Our 4th major concern is currently the family's lack of powers of attorney. Powers of attorney are an important way for individuals to protect themselves and their assets when they become incapacitated. Now, for the purposes of the Madisons, we are only going to explore 2 different types of powers of attorney. First is durable. These types of powers of attorneys grant powers from the day they're signed until either they are revoked or the principal passes away. The second power of attorney we're going to look at are contingent or springing powers of attorney. These types of powers of attorney only go into effect after certain conditions are met, such as if the principal becomes incapacitated. Why these 2 powers of attorney? Simple. We want the agent to maintain their power even if the principal is incapacitated. In that case, As long as the power of attorney covers both health and finance, the agent should be able to cover the bulk of the principal's duties. Our fifth and final concern regards advanced medical directives. These are the final stopgaps to protect individuals when they become incapacitated, especially when it comes to medical care. The main type of medical directive we want the Madisons to consider are going to be living wills. Living wills outline what a patient does and does not consent to in the event of an emergency, even if they can't express it themselves. This means living wills can help protect both Katie and Nicholas from expensive, invasive, and painful procedures they wouldn't otherwise consent to. It can also help protect the rest of the family from guilt by removing their ability to make difficult medical choices on behalf of both Nicholas and Katie. To reiterate, we want the Madisons to build their estate goals. We want Katie to create her own will to avoid her assets falling into state intestacy. We want a joint trust to be built to help house and distribute assets in the event of their death. We want a guardian selected to help look after minor children's welfare in the event the worst should happen. And we would like to see powers of attorney documents and advanced medical directives built to help protect the family, their assets, and their estate in the event of incapacitation. These are going to be the steps that help protect the Madison family going forward.